Hello, fanatics. Do you know what time it is? It is True Crime Storytime. We are here to discuss another depraved individual. A big thank you for all the love and support for last week's premiere, which was, of course, Theodore Bundy, aka Ted. That took me down some very, very dark avenues, I will not lie. I never do, but some very dark places. And that's the risk that you run when you do true crime story times. But yeah, thank you for all the love and support that went into that episode, because it was difficult to put that all together and all the research that I did, so I appreciate that. Today's episode comes courtesy of Angela Cooper, a very dear fanatic here on my channel, and she suggested this guy, and here we go again. Yeah, we're going down some more dark avenues. I just want to give a big shout out to all of you who make my premiere. I really do enjoy discussing these cases, and I enjoy being in your company. And for those of you who are on replay, I appreciate you for watching and leaving me comments and your thoughts down below. I really do appreciate that. So today we will be discussing Robert William Pickton. Pickton was born to Leonard and Louise Pickton, a family of pig farmers in British Columbia. There is a port, but I can't pronounce where that is. It's 27 kilometres, 17 miles east of Vancouver. His older sister Linda was sent to live with relatives in Vancouver, as their parents thought that the family pig farm would be an inappropriate setting to raise a young lady. Robert and his younger brother David began working at the farm at an early age. Louise, Mummy, was very demanding, prioritising the pigs over the brothers' personal hygiene and forcing them to work long hours raising the farm's livestock. She often sent them to school in unwashed, dirty clothes, reeking of manure, earning the brothers the nickname Stinky Piggy from their classmates. Pickton was strongly attached to his mother and had little interaction with his abusive father. Can't say the mum wasn't abusive, but okay. When he was in his early teens, he used his savings to buy a calf, which became his beloved pet. One day, after failing to find it after school, he was told by his mother to check the barn, where He was heartbroken to find it slaughtered. Pickton dropped out of school in 1963 at the age of 14 and acquired a position as a butcher's apprentice. In 1970, he left his apprenticeship to work full-time at the family farm. His father died in 1978 and his mother died the following year, leaving the farm to Pickton and his two siblings. Linda and David did not want the farm. David took over the house and Robert began running the farm on his own while living in a remote area of the property in a trailer. Worker Bill Hiscox called the farm a, quote, creepy looking place and described Pickton as a, quote, pretty quiet guy whose occasional bizarre behaviour, despite no evidence of substance abuse, would draw attention. The Pickton brothers began to neglect the site's farming operations. They registered a non-profit charity, the Piggy Palace Good Times Society, with the Canadian government in 1996, claiming to, and I quote, organise, coordinate, manage and operate special events, functions, dances, shows and expeditions on behalf of service organisations, sport organisations and other worthy groups. End quote. Its events included raves and wild parties featuring Vancouver sex workers and gatherings in a converted slaughterhouse on the farm at 953 Dominion Avenue in Port Coquitlam. Am I saying that right, Angela? Coquitlam. Not sure, but we'll go with it. These events attracted as many as 2,000 people. Members of the Hells Angels were known to frequent the farm. Now, when they registered it, and it was all parties, dances, and you have all of these like barn houses that are converted into events that host line dancing, say, or social events. And I thought, lovely, how lovely, until it was not that at all, but okay. On March 23rd in 1997, Pickton was charged with attempted murder of Wendy Lynn Izetta, whom he had stabbed several times during an altercation at the farm. Wendy had informed police that Pickton had handcuffed her, but that she had escaped after suffering several lacerations. She told them she had disarmed him and stabbed him with his weapon. Pickton sought treatment at Eagle Ridge Hospital, while Wendy recovered at the nearest emergency room. He was released on bond on $2,000 Canadian bond. The charge was dismissed in January 1998. Months later, the Picktons were sued by Port Coquitlam officials for violating zoning ordinances, neglecting the agriculture for which it had been zoned, and having altered a large farm building on the land for purpose of holding dances, concerts and other recreations. The Picktons ignored it. They ignored the legal pressure and held a 1998 New Year's Eve party, after which they were faced with an injunction banning future parties. The police were, quote, authorised to arrest and remove any person, end quote, attending future events at the farm. The society's non-profit status was removed the following year for inability to produce financial statements. It was subsequently disbanded. Now that's going to probably happen when you ignore the law. Over the course of 3 years, Hiscox, the worker, noticed that women who visited the farm eventually went missing. On the 6th of February 2002, police executed a search warrant for illegal firearms at the property. Robert and David Pickton were arrested, and police obtained a second warrant using what they had seen on the property to search the farm as part of the British Columbia Missing Women investigation. Personal items belonging to missing women were found at the farm, which was sealed off by members of the joint RCMP Vancouver Police Department Task Force. The following day, Pickton was charged with weapon offences. Both of the Picktons were later released. However, Robert Pickton was kept under police surveillance. On February 22nd, 2002, Robert Pickton was arrested and charged with 2 counts of first-degree murder in the deaths of Serena Abbotsway and Mona Wilson. On the 2nd of April, 3 more charges were added for the murders of Jacqueline McDonnell, Diane Rock and Heather Bottomley. A 6th charge for the murder of Andrea Jodesbury was laid on April 9th, followed shortly by a 7th for Brenda Wolfe. On September 20th, 4 more charges were added for the slayings of Georgina Papin, Patricia Johnson, Helen Hallmark and Jennifer Firminger. 4 more charges for the murders of Heather Chinnock, Tanya Hollick, Sherry Irvin and Inga Hall were laid on October 3rd, bringing the total to 15. This was the largest investigation of any serial killer in Canadian history. On May 26, 2005, 12 more charges were laid against Pickton for the killings of Cara Ellis, Andrea Borhaven, Deborah Lynn Jones, Marnie Frey, Tiffany Drew, Kerry Koski, Sarah DeFries, Cynthia Felix, Angela Jardine, Wendy Crawford, Diana Melnick, and a Jane Doe. bringing the total number of first-degree murder charges to 27. Excavations continued at the farm throughout November 2003. The cost of the investigation is estimated to have been 70 million Canadian dollars by the end of 2003, according to the provincial government. As of 2015, the property is fenced off under the Crown in right of British Columbia. In the meantime, all the buildings on the property, except a small barn, has been demolished. Forensic analysis proved difficult because the bodies may have been left to decompose or be eaten by insects and pigs on the farm. During the early days of the excavations, forensic anthropologists brought in heavy equipment, including two 50-foot flat conveyor belts and soil sifters, to find traces of human remains. On March the 10th, 2004, the government revealed that Pickton may have ground up human flesh and mixed it with pork he sold to the public. The province health authority later issued a warning. Another claim was made that he fed the bodies directly to his pigs. A preliminary inquiry was held in 2003, the testimony from which was covered by a publication ban until 2010. At the inquiry, the fact was revealed that Pickton had been charged with an attempted murder in connection with the stabbing of Wendy Lynn Isetter in 1997. Wendy testified at the inquiry that after Pickton had driven her to the Port Coquitlam farm and had sex with her, he slapped a handcuff on her left hand, stabbed her in the abdomen. She stabbed Pickton in self-defense. Later, both she and Pickton were treated at the same hospital, where staff used a key they found in Pickton's pocket to remove the handcuffs from her wrist. The attempted murder charge against Pickton was stayed on January 27, 1998, because the woman had drug addiction issues and prosecutors believed her to be too unstable for her testimony to help secure a conviction. The clothes and rubber boots Pickton had been wearing that evening were seized by the police and left in an RCMP storage locker for more than 7 years. Not until 2004 did lab testing show that the DNA of the two women, Borehaven and Ellis, were on the items seized from Pickton in 1997. In 1998, according to Vancouver Police Detective Constable Lorimer Shenhere, he learned of a call made to a police tip phone line stating that Pickton should be investigated in the case of the women's disappearances. According to the constable's account, described at length in his 2015 book about the case, he struggled to attract sufficient police resources and attention to the case until the 2002 search of the Pickton's farm by the RCMP. In 1999, Canadian police had received a tip that Pickton had a freezer filled with human flesh on his farm. Although they interviewed Pickton, who denied killing the missing women, and obtained his consent to search his farm, the police didn't conduct a search at that time. Pickton's trial began on January the 30th in 2006 in New Westminster. Pickton pleaded guilty. He went to jail, and that's the end of the story. Yeah, they never plead guilty, do they? He pleaded not guilty to 27 charges of first-degree murder in the Supreme Court of British Columbia. In a court of law, there is a phase where they determine what evidence is going to be used before the jury. This part of the trial took most of the year. Reporters were not allowed to disclose any of the material presented in the arguments. On March the 2nd, one of the 27 counts was rejected by Justice James Williams for lack of evidence. I mean, really, you got 26 others. On August the 9th, Justice Williams severed the charges, splitting them into one group of 6 and another group of 20. So he's dismissed one, so now there's 26 cases against him. He's taken 6 of those cases, and he's going to try him for them, and then a group of 20. The trial proceeded on the group of 6 counts. The remaining 20 counts could have been heard in a separate trial, but ultimately were stayed on August the 4th, 2010. Because of the publication ban, full details of the decision are not publicly available, but the judge has explained that trying all 26 charges at once would put an unreasonable burden on the jury, as the trial could last up to 2 years. It also would have an increased chance for a mistrial. Now, okay, I'm with him now. But I think what they might have done was do 6, then the 20, but then break down the 20. Do you know what I mean? So that they just pile on the case loads, or the guilty verdicts, hoping that he gets guilty, obviously. But that kind of makes sense. And the poor jury. Yeah, he kind of has a point. The judge added that the 6 counts he chose had materially different evidence from the other 20. Office of Inspector General Senior Investigator R.J. McDougall was case agent for the investigation. The date for the jury trial of the first 6 counts was initially set to start January the 8th, 2007, but was later postponed to January 22nd. On that date, Pickton faced first-degree murder charges in the deaths of... You're going to have to forgive me, I'm going to have to use surnames here. Frey, Abbotsway, Papin, Jodesbury, Wolfe and Wilson. The media ban was lifted, and for the first time Canadians heard the details of what was found during the long investigation. Gonna get graphic here, okay? Skulls cut in half with hands and feet stuffed inside. The remains of one victim was found stuffed in a garbage bag, and her blood-stained clothing found in Pickton's trailer. Part of another victim's jawbone and teeth found beside Pickton's slaughterhouse. A .22 caliber revolver with an attached dildo containing both his and victim's DNA. In a videotaped recording played for the jury, Pickton claimed to have attached the dildo to his weapon as a makeshift silencer. We're all dumb. We all get it. Oh, dear me. This explanation was impractical at best, as revolvers are near impossible to silence in this manner. Called it. As of February 20, 2007, the following information has been presented to the court. During Pickton's trial, lab staff testified that about 80 unidentified DNA profiles, roughly half male and half female, have been detected on evidence. The items police found inside Pickton's trailer: a loaded .22 revolver with, the silencer over the barrel and one round fired, boxes of .357 Magnum handgun ammunition, night vision goggles, 2 pairs of faux fur-lined handcuffs, a syringe with 3mm of blue liquid inside, and Spanish fly aphrodisiac. A videotape of Pickton's friend Scott Chubb saying Pickton had told him a good way to kill a female heroin addict was to inject her with windshield washer fluid. A second tape was played for Pickton, in which an associate named Andrew Bellwood said Pickton mentioned killing sex workers by handcuffing and strangling them, then bleeding and gutting them before feeding them to the pigs. Photos of the contents of a garbage can found in Pickton's slaughterhouse, which held some remains of Mona Wilson. In October 2007, a juror was accused of having made up her mind already that Pickton was innocent. The trial judge questioned the juror, saying, quote, "It's reported to me you said from what you had seen you were certain Mr. Pickton was innocent. There was no way he could have done this. That the court system had arrested the wrong guy," end quote. The juror completely denied this. Justice Williams ruled that she could remain on the jury since it had not been proven she made the statements. Justice James Williams suspended jury deliberations on December the 6th, 2007, after he discovered an error in his charge to the jury. Earlier in the day, the jury had submitted a written question to Justice James requesting clarification of this charge, asking, quote, "Are we able to say yes, i.e. find him guilty, if we infer the accused acted indirectly?" On December 9th, 2007, the jury returned a verdict that Pickton was not guilty on 6 counts of first-degree murder, but is guilty on 6 counts of second-degree murder. A second-degree murder conviction carries a punishment of a life sentence with no possibility of parole for a period between 10 and 25 years to be set by the trial judge. On December the 11th, 2007, after reading 18 victim impact statements, British Columbia Supreme Court Judge Justice James Williams sentenced Pickton to life with no possibility of parole for 25 years, the maximum punishment for a second-degree murder, and equal to the sentence which would have been imposed under a first-degree murder conviction. Quote, "Mr. Pickton's conduct was murderous, and repeatedly so. I cannot know the details, but I know this. What happened to the victims was senseless and despicable," end quote, said Justice Williams in passing the sentence. The British Columbia Court of Appeal rendered judgment in June 2009 on 2 appeals, one brought by the Crown prosecution, the other brought by the defence. On January 7th, 2008, the Attorney General filed an appeal in the British Columbia Court of Appeal against Pickton's acquittals on the first-degree murder charges. The grounds of appeal relate to a number of evidentiary rulings made by the trial judge, certain aspects of the trial judge's jury instructions, and the ruling to sever the 6 charges Pickton was tried on from the remaining 20. Some relatives of the victims in the case were taken aback by the announcement of a Crown appeal, especially because Attorney General Wally Opal had said a few days earlier that the prosecution would likely not appeal. Although Pickton had been acquitted on the first-degree murder charges and was convicted of second-degree murder and received the same sentence as he would have on first-degree murder convictions, the relatives of the victims expressed concern that the convictions would be jeopardised if the Crown argued that the trial judge had made errors. Opposition critic Leonard Krog criticised the Attorney General for not having briefed the victims' families in advance. Opal apologised to the victims' families for not informing them of the appeal before it was announced to the general public. Opal also said that the appeal was filed largely for, quote, strategic reasons, in anticipation of an appeal by the defence. The prosecution's rationale was that if Pickton appeals his convictions, and if that appeal is allowed, resulting in a new trial, the prosecution will want to hold that new trial on the original 26 charges of first-degree murder. But the Crown would be precluded from doing so unless it had successfully appealed the original acquittals on the first-degree murder charges, and the severance of the 26 counts into one group of 6 and one group of 20. Under the applicable rules of court, the time period for the Crown to appeal expired 30 days after December 9th, when the verdicts were rendered, while the time period for the defence to appeal expired 30 days after December the 11th, when Pickton was sentenced. That is why the Crown announced its appeal first, even though the Crown appeal is intended to be conditional on an appeal by the defence. If the defence had not filed an appeal, then the Crown could have withdrawn its appeal. On the 9th of January 2008, lawyers for Pickton filed a notice of appeal in the British Columbia Court of Appeal, seeking a new trial on 6 counts of second-degree murder. The lawyer representing Pickton on the appeal was Gil McKinnon, who had been a Crown prosecutor in the 1970s. The notice of appeal enumerated various areas in which the defence alleged that the trial judge erred. The main charge to the jury, the response to the jurors' questions, amending the jury charge, similar fact evidence, and Pickton's statements to the police. The British Columbia Court of Appeal issued its decision on June 25, 2009, but some parts of the decision were not publicly released because of publication bans still in effect. The Court of Appeal dismissed the defence appeal by a 2-1 majority. Due to a dissent on a point of law, Pickton was entitled to appeal to the Supreme Court of Canada without first seeking leave or to appeal. His notice of appeal was filed in the Supreme Court of Canada on August the 24th, 2009. The Court of Appeal allowed the Crown appeal, finding that the trial judge erred in excluding some evidence and in severing the 26 counts into one group of 20 counts and one group of 6. The order resulted from this finding was stayed, so that the conviction on the 6 counts of second-degree murder would not be set aside. On the 26th of June 2009, Pickton's lawyers confirmed that they would exercise his right to appeal to the Supreme Court of Canada. The appeal was based on the dissent in the British Columbia Court of Appeal. While Pickton had an automatic right to appeal to the Supreme Court of Canada based on the legal issues in which Justice Donald had dissented, Pickton's lawyers applied to the Supreme Court of Canada for leave to appeal on other issues as well. On November 26, 2009, the Supreme Court of Canada granted this application for leave to appeal. The effect of this was to broaden the scope of Pickton's appeal, allowing him to raise arguments that had been rejected unanimously in the Court of Appeals, not just arguments that had been rejected by the 2-1 majority. On July 30th, 2010, the Supreme Court of Canada rendered its decision, dismissing Pickton's appeal and affirming his convictions. Yay! After all that, you're staying in prison. The argument that Pickton should be granted a new trial was unanimously rejected by the justices of the Supreme Court of Canada. Yeah! He's staying in prison. Although unanimous in its result, the Supreme Court split 6-3 in its legal analysis of the case. The issue was whether the trial judge made a legal error in his instructions to the jury, and in particular in his re-instruction responding to the jury's question about Pickton's liability if he was not the only person involved. Writing for the majority, Madam Justice Sharon found that, quote, the trial judge's response to the question posed by the jury did not adversely impact on the fairness of the trial, end quote. She further found that the trial judge's overall instructions with respect to the other suspects, quote, captured the alternative routes to liability that were realistic in issue in this trial. The jury was also correctly instructed that it could convict Mr. Pickton if the Crown proved this level of participation coupled with the requisite intent. End quote. Mr. Justice LaBelle, writing for the minority, found that the jury was not properly informed of the legal principles which would have allowed them as triers of fact to consider evidence of Mr. Pickton's aid and encouragement to have an unknown shooter as an alternative means of imposing liability for the murders. However, LaBelle would have implied the so-called curative proviso so as to not overturn his convictions. British Columbia Crown spokeswoman Neil Mackenzie announced that the prosecution of Pickton on the other 20 murder charges would likely be discontinued. Quote, in reaching this position, the branch has taken into account the fact that any additional convictions could not result in any increase to the sentence that Mr. Pickton has already received. End quote. Families of the victims had varied reactions to this announcement. Some were disappointed that Pickton would never be convicted of the 20 other murders, while others were relieved that the gruesome details of the murders would not be aired in court. In 2010, the Vancouver Police Department issued a statement that an, quote, an exhaustive management review of the missing women investigation had been conducted, and Vancouver Police Department would make all the review available to the public once the criminal matters were conducted and the publication bans are removed. In addition, the Vancouver Police Department disclosed that for several years it has communicated privately to the provincial government that it believed a public inquiry would be necessary for an impartial examination of why it took so long for Robert Pickton to be arrested. End quote. In August of that year, the Vancouver Police Department released the Missing Women Investigation Review. At a press conference, Deputy Chief Constable Doug Lepard of the Vancouver Police Department apologised to the victims' families. Quote, I wish from the bottom of my heart that we would have caught him sooner. I wish that the several agencies involved, that we could have done better in so many ways. I wish that all the mistakes that were made we could undo. And I wish that more lives would have been saved. So on my behalf and behalf of the Vancouver Police Department and all the men and women that worked on this investigation, I would say to the families how sorry we all are for your losses, and because we did not catch this monster sooner. End quote. After Robert Pickton lost his final appeal at the Supreme Court of Canada, the Missing Women Commission of Inquiry, chaired by Wally Opal, was called to examine the role of the Vancouver Police and the RCMP in the disappearances and murders of women in the downtown East Side. Families of the missing and murdered women have been calling for public hearings since before Pickton was arrested and eventually convicted of 6 murders. The Commission's final report submission to the Attorney General was dated November 19th, 2012 and was released to the public on December the 17th. During the inquiry, lawyers for some of the victims' families sought to have an unpublished 289-page manuscript authored by former police investigator Laurie Sheena entered as evidence and made entirely public. Several passages were read into the inquiry's record, but Commissioner Opal declined to publicise the entire manuscript. During a court hearing on August the 4th, 2010, Judge Williams stated that Pickton should be committed to a federal penitentiary. Up to that point, he had been held at a pretrial institution. In June 2018, he was allegedly transferred from Kent Institution in British Columbia to another penitentiary in Port Cartier in Quebec. Pickton had faced a further 20 first-degree murder charges involving other female victims from Vancouver's downtown east side. On February the 26th, 2008, a family member of one of the 20 women named as an alleged victim told the media that the Crown had told her a trial on the further 20 counts might not proceed. On August the 4th, 2010, Crown prosecutors stayed the pending murder charges against Pickton, ending the prospect of any further trials. The 20 charges were formally stayed by Crown Counsel Melissa Gillespie during a British Columbia Supreme Court hearing at New Westminster. Most, but not all, of the publication bans in this case were lifted by the trial judge James Williams of the British Columbia Supreme Court after lawyers spent hours in court going through the various complicated bans. On August the 6th, 2010, various media outlets released a transcript of conversations between an RCMP undercover operator and Pickton in his holding cell. While the RCMP censored the undercover officer's name throughout most of the document, his name was left uncensored in several portions of the document that made the RCMP released to the public. This uncensored version was available to the public through Global News, CTV News and the Vancouver Sun for about an hour before being pulled and re-edited. The extent of any damage this mistake caused the undercover officer is not known. Again, as I did with the Ted Bundy case, I just want to pay homage to the victims. Serena Abbotsway, aged 29, when she disappeared in August 2001. Her foster mother reported her missing on August 22nd, 2001. Mona Lee Wilson, aged 26, when she went to her doctor on November 30th, 2001 and was reported missing that night. Andrea Josbury, aged 22, when last seen in June 2001. Brenda Ann Wolfe, aged 32, when last seen in February 1999. Marnie Lee Frey, last seen August 1997. Georgina Faith Papin, last seen in January 1999. Jacqueline Michelle McDonnell, 22, when she was last seen in January 1999. Diane Rosemary Rock, 34, when she was last seen October the 19th, 2001. Heather Kathleen Bottomley, 27, when she was last seen. Jennifer Lynn Firminger, last seen in 1999. Helen May Hallmark, last seen August 1997. Patricia Rose Johnson, last seen March 2001. Heather Chinnock, 30, when she was last seen in April 2001. Tanya Hollock, 23, last seen in October 1996. Sherry Irvine, 24, when last seen in 1997. Inga Monique Hall, 46, when last seen in February 1998. Tiffany Drew, last seen December 1999. Sarah DeFries, last seen April 1998. Cynthia Felix, last seen December 1997. Angela Rebecca Jardine, last seen November 20th, 1998. Diana Melnick, last seen December 1995. Jane Doe, charge lifted. Deborah Lynn Jones, last seen December 2000. Wendy Crawford, last seen in December 1999. Kerry Koski, last seen January 1998. Andrea Faye Borhaven, last seen in March 1997. Cara Louise Ellis, aka Nikki Trimble, 25, when last seen in 1996. Pickton refused to enter a plea on the charge involving this victim, known in the proceedings as Jane Doe. So the court registered a not guilty plea on his behalf. Quote, the count, as drawn, fails to meet the minimal requirements set out in section 581 of the Criminal Code. Accordingly, it must be quashed. End quote, wrote Justice James Williams. The detailed reasons for the judge's ruling cannot be reported in Canada because of the publication ban covering this stage of the trial. Pickton is implicated in the murders of the following women, but charges have not yet been laid, and this is not all of them. Mary Ann Clark, Yvonne Marie Bowen, Dawn Teresa Cray. 2 unidentified women. After Pickton was arrested, many people started coming forward and talking to the police about what had taken place at the farm. One of the witnesses that came forward was Lynn Ellingson. Lynn claimed to have seen Pickton skinning a woman hanging from a meat hook years earlier, and that she did not tell anyone about it out of fear of losing her life. Additionally, Lynn admitted that she blackmailed Pickton about the incident on more than one occasion. Okay, well, you wasn't that scared to blackmail him, but you was scared to go to the police. No words. The victim's children filed a civil lawsuit in May 2013 against the Vancouver Police Department, the Royal Canadian Mounted Police, the RCMP, Royal Canadian Mounted Police, and the Crown for failing to protect the victims. They reached a settlement in March 2014 where each of the children was to be compensated $50,000 Canadian dollars without an admission of liability. In August 2006, Thomas Loudemy, a 27-year-old Fremont, California resident, claimed that he had received 3 letters from Robert Pickton in response to letters he sent under an assumed identity. In the letters, Pickton allegedly speaks with concern about the expense of the investigation. asserts his innocence, quotes and refers to the Bible, praises the trial judge and responds in detail to information in Laudamy's letters, which were written in the guise of Maya Barnett, a down-on-her-luck woman, was broken by the Vancouver Sun in an exclusive published on Saturday the 2nd of September 2006, and as of that date neither law enforcement nor any representative of Pickton has verified the authenticity of these letters. The Sun, however, has undertaken several actions to confirm the documents' authenticity, including confirming that the outgoing stamps are consistent with those of the North Fraser Pretrial Centre where he was being held, confirming through a representative of Canada Post that the outgoing stamps are not forgeries, and confirming that the machine, identifiable with a serial number included in the stamp, used to stamp the envelope, is the machine used by the facility. Laudamy claimed not to have kept copies of his outgoing letters to Pickton, and as of the 4th of September 2006, no information on their existence has been forthcoming from Pickton or his representatives. Laudamy had a history of writing to accused and convicted criminals, in some instances under his own identity, as well as correspondence with Clifford Olson, and in others in the guise of a character he believes will be more readily accepted by the targets of the letters. Laudamy, an aspiring journalist, claimed that his motivation in releasing the letters was to help the public gain insights into Pickton. There you go, guys. Wow. I know it may have come across as complicated. I felt it was complicated, but maybe listening to it might be easier. But I wanted to give you the full in-depth, behind the scenes look into this case, because I think, personally speaking, I don't know if you agree, yay that he's in prison, and I totally understand why the judge separated them, because it would be overwhelming and you are at risk of going, hey, he done this, and if you're doing all 26, because sadly one was taken out of the charges, if the jury sit there and go, yeah, guilty to that one, guilty to that one, guilty to that one, then they come across one of the cases where it might induce doubt, it will then induce doubt into all of them. So I totally get it. Go with the most concrete 6, get him in prison. I don't understand how they didn't find him guilty of first degree, but there you go. But I do think he should face up to the other 20. Yes, he's not going to serve any longer. Do you know what I mean? But it would be closure for that family. I totally understand them not wanting to have it all out in court, because they probably were there for the 6 that he was convicted of, and that was brutal enough to know that probably happened to their daughter, sister, aunt, and so on. I get it, but I'm just saddened for the rest that don't. They know, the families know, and you know, I think they deserve that, but that's just me speaking. He has actually solidified being in my true crime playlist. It's not a case I was familiar with, but it's a case that I'm very, very saddened by. The sheer number, the sheer depravity of what this man did to young women, it is disgusting and heartbreaking and tragic. And of course my heart goes out to the families and their loved ones and so on. Oh, it always makes me sad. But there you go. Yeah, as always, leave your thoughts and comments if you're on replay. Thank you so much for joining me for tonight's episode, guys. I do appreciate it. I love spending time with you in the premiere. And yeah, Robert Pickton, what a disgusting individual. Another question I have, thinking about it, is that in the beginning, his mum and dad died, and the sister is by accounts nowhere near the farm, but David was the brother. Are you seriously telling me he had nothing to do with this, or no knowledge? I mean, even the worker, Hiscox, was noticing that people were at this party one minute and on the news as missing the next. He clocked it, so I'm not quite sure why the brother had absolutely nothing to do with it or absolutely no knowledge behind it. There's no documentation on that, so I'm speaking purely in speculation. But, you know, there you go. That's a question for you guys. Wow. I'm sorry, I didn't tell you what I was working on. I'm working on a little Christmas gnome, which is really inappropriate. But I don't have any true crime murder. Yeah, I'm not going to do customs of serial killers or anything like that to fit into my true crime story time. That really would be morbid. But yeah, obviously I'm a diamond painting channel. I diamond paint while I talk about true crime, and you know, there you go. That's my reasoning. I diamond paint while discussing these individuals. But yeah, thank you so much, you guys. I really do appreciate it. I was going to jump on live after this, not to talk about it, but you know, to spend time with my fanatics. I kind of need a lift. But yeah, let me know in the comments. Do you want me to jump on live? If you want to spend an hour or two with me, let me know. If you've had enough of me, that's fair enough too. I won't be offended. But yeah, thank you so much for joining me. And I will see you next Thursday, 8 p.m. I think it's going to be another long one. It's quite an in-depth one. Yeah, and one I think we're all familiar with. I think. I'm familiar with the name, wasn't familiar with the crime. So that remains to be seen. I shall see you next week. Thank you so much for joining me. If you're on replay, love you lots. Thank you very much. And yeah, thank you guys for spending some time with me tonight. I really do appreciate it. Have a wonderful rest of your evening. And yeah, stay safe. Stay safe. Bye.